All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Thank you. Please be seated. Good morning. We're here in our cause number CACV140226 involving U.S. Airways Inc. versus Quest Corporation et al. This is the time set for oral argument. And, each side will have 20 minutes, and since there's a cross appeal, I don't know how Quest and ELM may handle it, but we'll let you manage that. These proceedings will be recorded audio. We also video. They'll be on our website. They'll also be on YouTube. You know, you can put them to music later on and, you know, have a wonderful time.
It's a sleep aid.
We have read the briefs. We've conferenced this matter. Heck, you know, the Supreme Court even threw us a challenge on Friday by issuing an opinion talking about duty. So, and tried to get through that as well. So, with that in mind, counsel.
Thank you, Your Honor. Oh, I probably need this down so that it can record me. No? It's fine? Oh, good.
No, yeah, put it down so we can hear you as
okay.
opposed to recording,
Okay.
know, just in case.
May it please the Court, Jennifer Cranston from the law firm of Gallagher and Kennedy on behalf of the appellant, cross-appellee, U.S. Airways. I plan to reserve approximately 5 minutes for rebuttal, so I'm hoping I can do that. I know there's a lot of ground to cover. I'm happy to hear that you've read the briefs and are familiar with the facts and procedural history. So with that, I will jump right to the issues that are at the heart of this appeal. There are two key issues. One is the application of Quest's tariff to U.S. Airways claim, and the second is the issue of duty. I plan to spend most of my time on duty, but wanted to briefly go through the issues regarding the tariff, and I'm happy to answer any questions you may have about the application of the tariff. As U.S. Airways indicated in its briefs, there are several reasons why the limitation of liability in the tariff should not apply to U.S. Airways claims. The first is that the scope of the tariff doesn't have anything to do with the obligation to locate and carefully mark underground facilities, and therefore the limitation of liability shouldn't be applied to a non-tariffed duty, especially owed to a non-customer.
Excuse me for interrupting.
Certainly.
Is there something in the language of the tariff that supports your point here?
Well, the tariff.
Or is it that there isn't something in the language of the tariff that supports application of it here? However you want to argue it.
Well, it's a little bit of both, to be honest. I mean, the tariff by its terms states that it is governing these services offered under the tariff. The obligation to locate and to mark an underground facility is not one of the services offered under the tariff.
Well, isn't it a derivative of a direct service to, you know, have, if you're going to have the lines underground and you've got to fix them or do anything, then you're going to have to, you know, do them non-negligently, and as a result, that's consumed within the rate?
That argument could be applied to everything that the utility does in the operation of its business, and that has not been the holding of and the application of the filed rate doctrine. As the U.S. Supreme Court, and specifically former Justice Rehnquist explained in the tariff, there is a limitation, and the limitation is found within the purpose of the filed rate doctrine and the purpose of these tariffs, which is to prevent discrimination in rates. So the utility can't charge something above or below the rate, can't provide a service, can't give a smoking deal to someone, and also to protect the jurisdiction of the regulator. Neither of those issues are affected by enforcing the state common law duty to properly locate and mark an underground facility. And we've cited a number of cases that also support that. The only case that Quest has been able to find that would contradict that concept is a California case that we've explained is really inapplicable here. Probably the most important reason for it being inapplicable is that the tariff at issue there was a tariff that was specifically written and endorsed by the California Corporation Commission. We don't have anything like that going on here. We don't have a public policy announcement by our state or by the Corporation Commission indicating this desire to limit these damages in the locate context.
In the locate context.
Yes,
Okay.
yes. The other problem with the tariff is if it is applied pursuant to contract law, then it can't be applied to U.S. Airways. We are a non-customer, and it was not a bargained for limitation of liability, and therefore does not comport with the requirements of Salt River v. Westinghouse. The third problem is if you apply it as law, you run into anti-abrogation clause problems. Specifically, the limitation is so extreme that it effectively eliminates U.S. Airways' reasonable possibility of obtaining redress for its very real damages.
Yeah,
Plus,
I certainly agree with your point that $586.40, as I recall, is hardly anything in the context of the loss here. On the other hand, don't our cases say that, well, you can't, even if it applies constitutionally, the anti-abrogation clause, it doesn't mean you can't regulate it. It just means you can't totally abrogate it.
well, but regulation has been defined to still allow redress, and this kind of limitation doesn't allow the type of redress that is anticipated in those cases.
$586 doesn't qualify for that?
It certainly presents a...
It's pretty minimal, I agree
Yeah,
with you.
it presents such a significant economic barrier that it doesn't make a lawsuit feasible. And therefore, there is no claim if that's all you're going to get.
It just exists in theory.
Yes, yes, which is some,
Sometimes that's good enough.
Well, but you also have the second part of the anti-abrogation clause, which specifically prevents limiting the amount of recoverable damages. And here that's distinguishable from your comparative and contributory fault. Here we have a specific limitation. Regardless of your fault or who's at fault, you have a specific limitation on the amount of damages, which triggers the second part of that clause.
Or foundationally, perhaps, did this cause of action exist at the common law before statehood?
Well, the case law regarding anti-abrogation specifically acknowledges that a duty need not have been recognized in its specific form at statehood. We have all sorts of cases where post-statehood recognized duties have been acknowledged as being protected under the anti-abrogation clause.
It's sort of like looking back and saying, well, we didn't have a case that recognized it in 1912, but we would have if we had.
Absolutely. I mean, Ontiveros, which wasn't acknowledged, the dram shop liability wasn't acknowledged until much long after state law. In fact, it was disallowed until more recently. Same thing with bad faith claim in the insurance context. Those have all been held to be protected by the anti-abrogation clause. So that does bring us, it's a nice segue to the duty issue, and I do want to make sure that I address some of the issues that were specifically raised in Quest's reply brief. But first, just looking at the Act, and that is, it's both the Act and conduct, but I want to focus on the Act for a basis of the duty owed by both defendants, because the Act, specifically 40-360.29b, creates a duty. Upon receiving a locate request, the Act imposes a duty on utilities and their contractors to promptly and carefully mark the location of the underground facility. The statute also indicates that the locating and marking of an underground facility is a matter of statewide importance, and that's found in 40-360.29b. That's another indicator that this is a public policy-based duty. And finally, the legislative history clearly indicates that in addition to protecting excavators, the legislature enacted this statute in order to protect the interests of customers and users of the facilities. And Quest hasn't explicitly or even implicitly disagreed with what the statute says or what the purpose of the statute is. Instead, in the reply brief, we've heard about arguments about negligence per se and about a lack of specific case law. On the negligence per se argument, it just doesn't fit here. Negligence per se only arises when you have a statute that creates a very specific standard of care. Here, we have a statute that creates a general reasonableness standard of care. And how we know that is when you look at the statute, it requires the utility and its contractor to carefully mark. And carefully is a defined term in 40-360.215, and it is defined as acting with reasonable care under the circumstances. We have a wealth of case law in Arizona that indicates that where you have a reasonableness standard under a statute, you don't have a negligence per se claim. And therefore, the statute of limitations issue and the negligence per se issue is really a non-issue. The second argument that Quest makes in its reply brief is that no court has specifically acknowledged the duty to protect line users from economic damages. And this argument, to me, it just doesn't make any sense, because if that were the standard in analyzing a duty, then this court would be frozen in time and would never have the ability to recognize any duty that a prior court had not specifically acknowledged. So I think the analysis is, and that's where I want to go next, is what's the framework under which prior case law gives you to analyze duty, and is that different in economic damage cases? Because that's what really this argument boils down to, is how can we owe a duty when the only damage is economic damage? And they cite to the Supreme Court's decision in Lips, in which certainly the court does reference concerns over onerous and possibly indeterminate liability. But as we pointed out in the briefs, if you look at the way the court analyzes the issue, the court and the courts after Lips and the courts before Lips don't apply a different analytical framework when analyzing duty. They look for relationships, they look for conduct, they look for public policy. And that's the exact same analysis that we're asking this court to apply. And so we've cited a lot of economic loss cases that apply that analysis. Steinberger, Sage, yes?
Our Supreme Court seems to question that in its most recent opinion in Guerra versus State, where they questioned McCutcheon to the extent they found that it would encompass economic harm under 323 without discussing it. But I think our Supreme Court over the last few years has said on a number of occasions, well, maybe we've just, misled people into thinking something like they did on the gift clause case and said, from now on, these are the rules, and you take it forward.
Certainly, this would have been an opportunity for the court to have said that. If I saw that that the decision absolutely questioned the economic interest, but then very quickly went on to say, but that is the law in Arizona. Economic damages are recoverable, and you can have a duty where only economic interests are involved. They could have said something completely different, but they didn't. And Guerra... But
they didn't have to, because they found no duty.
Certainly.
So to the extent that they, it would have been helpful for everyone.
But Guerra wasn't dealing with economic damages. I mean, there we have it was emotional distress damages. But again, the rationale employed by the court, the analytical framework, was the same that we see in all the other cases. Is there a relationship? Is there conduct? Is there a public policy? And interesting, what's significant about the court's, I think what's significant about the court's decision in that case is that they were already, they were trying to create consistency with a whole line of cases that had found no duty by police officers in the investigation context. We don't have that here. We don't have a whole line of cases where there's no duty owed by a utility or its contractor to appropriately mark. In fact, if anything, we have one case Ganal that indicates there is a duty there, and it is based upon the statute, or it's based upon the public policy that's analyzed in the statute. And the concern expressed by the court regarding the potentially increased litigation and exposure to damage that would accompany economic damage duty, you can say that about any number of duties that have been acknowledged by the court. And it seems to me that if you're going to start drawing lines, which I haven't seen the court draw, if you're going to start drawing lines, it can't be just based on economics. It can't be just because we don't want a particular group of defendants to not have to incur damages. It's got to be something more. There must be a more significant public policy issue supporting the acknowledgement of a no-duty rule. And we don't have that here. In fact, we have public policy on the other side. We have public policy that indicates that if you impose a duty, not only is there no risk of chilling a socially desirable contract, but you will encourage socially desirable conduct. You will have utilities who employ non-negligent locators. You will have them creating prints that adequately identify the location of their facilities.
Counsel, where would you draw the line then, as far as economic losses? Let's say that U.S. Airways had claims from 500 customers that said, look, I lost a job interview opportunity. I lost the opportunity to go see I was late for my daughter's wedding. I was late for, I mean, you could see 500 reasons because of I mean, maybe getting outlandish here with examples, but do you understand where would you cut off the economic losses? Because they could be tremendous.
I think there must be a stopping point. I agree. But duty isn't where you create that stopping point. I would suggest that you look at the proximate cause, proximate causation, causation in fact. You also have all the issues that should be tried, contributory negligence, comparative negligence. All of that will help limit those potentially unlimited damages. But just to say there is no duty and that utilities, can negligently mark their lines and they don't have to, pay a price because it's economic damages, that doesn't comport with public policy.
I was going to say, how is it square where the court found that Quest had a duty, though limited by the tariff, to the fact that ELM didn't have a duty?
I struggle with that one myself, because if Quest has a duty, it is a non-delegable duty, as ELM has said many times, and we have case law that tells us if you have a non-delegable duty, that independent contractor is just as responsible as the principal. So I have about 3 minutes left. I think I'd like to save that if.
Thank you.
Thank you.
Good morning. Good morning, Your Honors. Andrea Lovell on behalf of Quest Corporation, and I have with me in the courtroom my partner, Rudy Parga, also from Riley Carlock and Applewhite, as well as in-house counsel from Quest, Kevin Lanahaw. Your Honors, the reason we're here today is because U.S. Airways made a business decision to save money and purchase substandard telephone services through a non-party, and now it has buyer's remorse. So by way of a little bit of background, there were multiple circuits.
But wait a minute.
Sure.
Someone does some construction based upon faulty and negligent marking, and some lines are cut, and they're trying to seek remuneration for the value of that because you had bad maps. Allegedly.
Well, Your Honor, the Quest circuits in question actually weren't
the
ones that failed.
AT&T and
Verizon.
EDS.
Right. And that's, I think that's just the point I'm trying to make, is that those are.
Counsel, wouldn't that be an argument against that they needed to mitigate their damages? Again, seems like you're suggesting that they should have gone out and had a duplicate system to protect against the cutting of the lines.
Well, I do think that the responsibility in terms of what the affirmative conduct that created the risk here is actually U.S. Airways and the expert that they hired in EDS to select the substandard service, because I think those are actually the circuits that failed, not the Quest circuit here.
But that's a damages issue.
Okay.
That's not the duty issue or your potential protection under the tariff. You know, if we agree with the trial court, you've paid the damages and everybody goes home. If we disagree, then maybe you have to get into those arguments. But
Sure,
you know,
sure.
why, to address the arguments, shouldn't your duty that the court described translate to ELM, and then why can't then U.S. Air at least attempt to collect something other than that proportionate share of the service call?
Well, Your Honor, I think looking at the statute itself in terms of the duty argument, I think it's clear that U.S. Airways is not within the scope of the persons who are protected by the statute. Prior to 2007, the statute provided for liability to any injured party. And then in 2007, the statute was amended to limit the scope to liability only to underground facilities operators, and excavators, which U.S. Airways is neither. And I think in terms of the statute itself, because U.S. Airways is not within the class, it doesn't have a cause of action under the statute itself. And I think in terms of the negligence per se argument, that issue was addressed in the Sprint versus Western Innovations case that we cite in our briefing, and Judge Silver in the district court found that alleging a violation of the Underground Facilities Act is in fact an allegation of negligence per se that would be subject to a 1-year statute of limitations. And then I think what I am understanding U.S. Airways to be arguing is that even if the statute per se doesn't particularly cover them, the policy underlying the statute still somehow gives rise to a duty on the part of Quest. And I think that's a hard argument to sell in light of the statutory amendment, because I think we can all assume that if the legislature intended for end users or other third parties like U.S. Airways to be included within the protection, it wouldn't have limited the scope of those who are protected. It would have specifically included them as they had been in the past.
Well, that would take care of the old foreseeability issue.
Right.
That, since Supreme Court adopts it, Gibson, and got rid of that from at least what we used to learn in law school. But, you know, if the contractor calls you and says, we need to have your line staked, and you hire someone to do that, how do you avoid, at least as the trial court found, you know, that duty to do it, to have your contractor do it non-negligently?
Sure, and I think that underground facilities operators do under the statute have to mark the lines. The issue I see is that the liability extends only to excavators and underground facilities operators, and not infinitely. And I think Judge Brown made a good point about, you know, where do you draw the line? Because, you know, similar to a situation like this, what if service to eBay went out and everyone who's online about to place a winning bid suddenly has a claim for the, you know, 69 Chevy they were about to purchase? Or you know, even this week in the news there was an interesting article about an auction that was held by Christie's. Everyone participated telephonically, and there was actually a world record set of $179 million bid for a Picasso painting. So what happens in a situation where, you know, that person's service is cut? It may not even be a customer of the telecommunications company at issue. And in that case, exactly what the trial court judge observed in the situation of a Sears or a Nordstrom's, the liability could just be astronomical to the point where telecommunications companies wouldn't be able to insure the risk and wouldn't be able to continue providing services at rates that actually are workable for the consumer public.
So it sounds like a little conflation between your protection under the tariff separate from the duty.
Okay. From a duty standpoint, I think the statute is clear that the duty is not owed to end users or third parties like U.S. Airways. And I also think that common law doesn't provide a duty either. I haven't seen any common law cases extending duty on the part of a telecommunications company to an end user for purely economic harm. And I think the policy reasons that were set out by the Lips Court are very applicable here. From a tariff standpoint, I think the tariff, to the extent the court were to find a duty, I think the tariff certainly limits damages, and I don't think that the argument that we've heard today about U.S. Airways not being a customer changes that analysis. I think the express terms of the FCC tariff extend to both customers and any others, which clearly would cover U.S. Airways. And that argument was specifically addressed in the Collett case, which I think is very on point here. And the court in that case explained that essentially public utilities commissions like the ACC and the FCC bargain on behalf of everyone. And so when tariffs have the force and effect of law, which they do when they're filed, they're binding on everyone in the public. And that is, I think, the same reason why the benefit of the bargain argument that we've heard today doesn't work. In addition to U.S. Airways having, been represented by a self-proclaimed expert in selecting telecommunications services, I think the whole tariff framework contemplates that there is no individual bargaining. So even if U.S. Airways had been a direct customer of Quest for the services that went out, it wouldn't have had any additional ability to individually bargain a separate limitation of liability provision in a tariff. I think the whole point of the tariffs is that everyone is treated the same rates. And I think it goes beyond rates. I think it's clear in the cases that we've cited, Western Union versus Esteve Brothers and Abraham, that limitation of liability clauses are an inherent part of the rate.
Absent gross negligence or willful misconduct.
Sure, and that's why.
Would you say something about Ms. Cranston's argument that it simply doesn't apply to this excavation?
Sure, and that I think that's a good question, and that argument was specifically addressed by the Collett case as well. I think the tariff specifically on its face applies to anything related to the provision of services. The Collett case said the marking and locating of lines is specifically related to the provision of services because it's part of the telecommunications company's efforts to make sure that services remain in effect and are not interrupted.
Even though it's not specifically listed in the tariff.
Sure, that it's an integral part. And I think the Collett case came out exactly right. That.
Counsel, what about the truck that's driving to the site where the lines are marked and the truck gets into an accident?
Sure.
Does that relate to provision of services?
I think arguably no, it doesn't. And I do think that's where you draw the line. And I think the distinction is there. You're talking about not the provision of services, but property damage or personal injury, which we're not here arguing would be within the protection of the tariff.
If the truck struck a telephone pole and knocked it down and cut service in that manner?
Sure. I think that I do think that would still be, property damage and conduct outside the scope of simply providing services. I think, the marking and locating activities are specific to the continuation of service, whereas driving from point A to point B, I think, is more removed, and we're certainly not arguing for that type of analysis. I think at the end of the day, and I'll reserve some time and obviously let other defense counsel argue as well, but I think Quest makes a good point in its briefing, and that is that the duty analysis has to boil down to a common sense approach. And what I think U.S. Airways is doing today is asking this court to impose liability that could be astronomical, indeterminate, and I also think that the argument they're making simply would encourage every online retailer to put a middleman between itself and a telecommunications company to do an end run around a tariff and not be subject to the terms, which clearly isn't what is contemplated by the tariff regime.
Well, what about her argument with respect that at least the the tie to duty and economic harm is muddled. Sometimes it may seem clear, and other times it may not seem clear, as Gara seems to point out.
Right. And I think Gara wasn't limited to specifically economic harm, but I see your point. I don't think this is the case, or that these are necessarily the facts to impose a duty. I think these are issues of statewide importance in terms of, how is an indeterminate duty like what U.S. Airways is advocating for going to impact the provision of telecommunication services, and whether companies even want to stay in that business or have the ability to offer rates that anybody can afford at that point.
I know insurance companies sue each other all the time for all sorts of things.
Sure.
But surprisingly, there's not a lot of modern litigation involving utilities and others provide any guidance other than what parties have quoted to us.
Right, and I actually think you make an interesting point about the insurance, because when you look from an insurability standpoint about who is best equipped to insure against the risk of what happened here, I think it's clearly the user of the telecommunication services, because when Quest provides service, it often doesn't even know who the end user is, what that end user is using services for, whether or not the services are critical to its business, and what the impact would be if the services went out. And so Quest also doesn't have the ability to turn down, if it felt that service was too risky. For example, maybe it wouldn't want to provide service to U.S. Airways Data Operations Center if this type of liability was the consequence. It can't pick and choose. But by the same token, U.S. Airways is in the best position to know what it's using its services for. And that's why there are insurance policies like business interruption insurance that are available to the extent that there are critical systems at issue.
Well, okay.
I'll let Mr. Kastner speak. Thank you.
Good morning. May it please the court. John Kastner on behalf of ELM. With respect to the duty claim, Judge Brown, you asked a question as to where the stopping point is. And I think that within the case law, there is a stopping point when you consider both Gibson and Lips, and if you consider them together. And that is, I think, and in this case it's particularly relevant, the relationships between and among the parties. In Lips, as the court knows, the court indicated that liability for negligence in cases involving economic losses depends upon the existence of special reason for finding a duty of care. And then the Lips court went on to explain that it would find those situations where the relationship between the parties warranted it. For instance, duties in certain professional and business relationships. And those were all first-party relationships. For instance, attorneys, doctors, accountants. They could be subject to liability or had a duty to protect against economic losses. Negligent misrepresentation recognizes the duty to exercise reasonable care in preventing information, but to a limited class of recipients. And that's not the situation we have in this case. First of all, there's no claim for negligent misrepresentation. And second of all, it's kind of, I think it's to go back and look at what happened in this case. The court is aware that the owner of this property, not U.S. Airways, asked Skyline to build some carports. Skyline called Blue Stake, who got in touch with Quest. Quest sent my client to do the locate. My client has absolutely no relationship with U.S. Airways. Frankly, third party or otherwise. They didn't know of their existence, which is exactly the dangerous situation the court was discussing in the Lips case. None of the cases cited by U.S. Airways support the type of relationship that existed here, or support a claim for economic losses based on the type of relationship between ELM and U.S. Airways, because again, in this case, there is no relationship.
And so under that analysis, US Air couldn't get to Quest as well,
Correct.
irrespective of any negligence that resulted in their loss of telecommunications for a 4-hour period.
Correct. That is in keeping with both Gibson and Lips. In fact, in Gibson, what's important, one of the things I took away from the Gibson decision is the court said you should approach examining the relationships among the parties with caution, because you could be in danger of conflating the issue of duty with breach of duty and damages. So you have to be very careful and mindful of how you're examining the relationships of the parties as described in the Lips case. There's no privity of contract in this case, obviously. The contract between ELM and Quest, unlike the contract that U.S. Airways mentions in the Professional Sports versus Gillette case, is completely different. The contract in this case doesn't mention customers or users at all. And in the Gillette case, the agreement between the parties specifically provided for a scope of potential people that the security company would owe a duty to. As to public policy, I'm not going to reiterate what's already been argued. Well, I guess I am to some extent.
See, you can't.
I can't help myself
on your own promise. So.
I can't help myself. Arizona revised statute 40-36021 et al. Does not provide the public policy that U.S. Airways hopes. The legislative history they rely on is from 1981. It obviously does not apply to the amended 2007 statute, which provides a limited duty to a limited scope of potential entities. Customers and users is not one of them. The restatement, 324A, also does not support public policy in favor of finding a duty consistent with the facts in this case for economic losses as to either ELM or Quest. And with that, I'm finished unless there are any questions.
Thank you.
Thank you.
Do you want your 47 seconds? Oh, I was going to say for the cross appeal at the end.
Go over here. So there were a couple points that were made that I want to touch upon. The argument that by revising the statute in 2006 to take away an express civil right to damages somehow eliminates the protection of the statute really conflates the two issues. We have all sorts of case law that indicates that you don't have to have a civil right to damages under a statute to acknowledge that a statute demonstrates a public policy that protects. And Steinberger, I mean, when you want to look at a case that that is far-reaching, Steinberger says that the Fraudulent Recording Act is aimed at protecting everyone who could ever be a victim of that situation, and it's protecting economic losses, and it's based upon a statutory duty, not on the relationship. So I agree with counsel for ELM. You do have to be careful when you're talking about relationships because they can get fact-intensive, which is why you have other bases upon which to identify a duty, one of which is a statute, another is general public policy, another is conduct, and we've addressed all of those. Quest's articulation of what qualifies as provisioning services, I think, as demonstrated by the oral argument here today, is really, really broad. And what at least what I heard in oral argument was it was an attempt to narrow it by talking about just the type of damage. But I would point you to the tariff that was originally filed by Quest's affiliate in this case. It's part of the record. And that tariff has a limitation of liability clause that seeks to create immunity for personal injury and death. It actually says death in the tariff. So the concept that these are tariffs that are negotiated by our regulators on behalf of the customers and evidence a public policy and draw the appropriate lines, I think, went out the window when you have a tariff on the books in Arizona that says that a utility is not responsible for negligently caused personal injury and death. The concept also is that by creating this claim for economic loss, you're making the utility into an insurer. And I think there are a couple problems with that. The first is you're not an insurer because it's a regular negligence claim. So you have all the mitigation of damages and the contributory negligence protections. You're not an insurer. And the potential contributory negligence of a plaintiff, the court in Gibson made it very clear that has no place in the duty analysis. They're the individual who died and voluntarily drunk and voluntarily took the drugs, and the court said, no, we're not even going to look at that. That's not part of the duty analysis. Also, in terms of the potential safety for the utility, there are indemnification provisions in all of their tariffs, including the one at issue. So they can go back to AT&T and say, it's your fault, not ours, indemnify us. That doesn't mean that U.S. Airways shouldn't have a claim. So I apologize I took up all the time and didn't leave you guys any time to ask any questions.
Well, we can always take time for questions if we would like. Good? Okay, thank you.
Thank you.
Thank you. Just a couple quick points to mention in 47 seconds. First, neither Quest nor ELM in this case actually directed any conduct toward U.S. Airways, so I think it's important to keep that in mind. Second, with respect to the statute, I just think it's a tough sell to say that a statute that specifically removed a reference to all injured parties somehow reflects a public policy in the state of Arizona to extend liability to all injured parties. I think clearly the more common sense approach would be to say that those people intended to be covered by the statute are those that are specifically now enumerated in the statute. And finally,
doesn't that get into the kind of the anti-abrogation? Once you put people in, the legislature may change the language, but depending upon the timing, they may still be in because the policy otherwise exists.
Potentially, Your Honor, but I think, even the cases that were cited by U.S. Airways do say, including hazing and others, that there's a difference between regulation, which is I think what's happened here, and abrogation, which is in this situation where there's absolutely no cause of action whatsoever.
You have another point you wanted to make? Or?
I was just going to say that the tariff in question, the FCC tariff, has been in effect for 14 years. So to the extent that there's any concern about whether the FCC has an issue with it, I think it's safe to say that it doesn't. Thank you.
Thank you. We appreciate the argument. You've given us lots of things to think about. We will take this matter under advisement. We stand adjourned. Thank you.